Good evening. I'm going to call this meeting to order. We're going to start with a moment of silence followed by the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Just before roll call, I want to point out for the record, Ms. James just called me moments ago saying that she had an emergency in the family and she was not able to attend tonight. Mr. Velasquez, if you would, please call the roll.
Julius Wiggum.
Present.
Margaret Shepherd.
Here.
Edward Kennedy.
Here.
Cedric Barber II.
Present.
Troy McCoy.
Here.
Bernard James. Absent. Quorum is present.
Mr. Gagnon, any additions or deletions?
Yes, thank you. Jeff Gagnon, Assistant Director of Community Development. First, I'd like to just say, since Ms. James is unavailable to be here tonight with a family emergency, that Mr. McCoy as Vice Chair would step in as the chair role. Additionally, I'd also like to introduce Ms. Allison Goldberg, who is our newest Senior Planner and GIS Specialist. She's been with the city now for about 3 or 4 months, and she will be involved with the presentation process later on this evening. I would also like to reorder letter A and B under new business. So I'd like to hear letter B first before letter A. And I'd also like to add another item as item number C. For you on the dais, you have an 11 by 17 sheet that says Park Manor Plat number 2. This is associated with a replat for one of the CDC projects, which would subdivide a lot to allow for construction of 2 single-family homes, and there is a brief staff presentation as well for that item. So we'd like to have you add that on the agenda as item number C. Letter C, excuse me. That's it.
Thank you, Mr. Gagnon. Can you repeat her name? I heard Allison. What was the last name?
Allison Goldberg.
Welcome. Any disclosure by members? Any members wishing to disclose? Is there a motion to adopt the agenda with the changes that Mr. Gagnon has just stated?
So move.
Properly moved. Is there a second?
Second. Sir.
Moved by Mr. Kennedy, second by Mrs. Shepherd. Would you call the roll?
Julius Wiggum.
Yes.
Margaret Shepherd.
Yes.
Edward Kennedy.
Yes.
Cedric Barber II.
Yes.
Troy McCoy.
Yes.
Unanimous voting, motion approved.
Approval of the minutes of the August 25th, 2016 meeting. Is there a motion?
So moved.
It's been moved. Is there a second?
Second.
Moved by Mr. Kennedy, and there was a second by Mrs. Shepherd. Would you call the roll?
Julius Wiggum.
Yes.
Margaret Shepherd.
Yes.
Edward Kennedy.
Yes.
Cedric Barber II.
Yes.
Troy McCoy.
Yes.
Unanimous voting, motion approved.
Having no unfinished business, we will move to number 7, new business, and letter number B, as Mr. Gagnon just rearranged.
Sorry about that for the sheet. So we are ready for letter B. Okay, letter B is an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, repealing Chapter 25, of the city's Code of Ordinances entitled Flood Prevention and Protection, and enacting a new Chapter 25 entitled Floodplain Management, in order to provide for current procedures and criteria for development in flood hazard areas, to provide for administration of said chapter, to provide definitions, to provide flood-resistant development standards, and to adopt current flood hazard maps, to provide for conflicts, severability, and codification, and providing for an effective date. That's why you don't run back to your office, because you're out of breath. Sorry about that. So, in summary, Chapter 25 of the City's Code of Ordinances was approved in 2002 through Ordinance Number 2929. As you can imagine, over the past 15 years or so, there have been modifications in floodplain management, so the existing ordinance is now outdated. The city is part of what is known as the CRS, or City Community Rating System. And what that does is it allows for potential insurance deductions for flood insurance, so long as you meet certain criteria. One of the requirements to be in the program and to recertify, which the city is currently in the process of doing, is to have the city's floodplain regulations be consistent with the Florida Division of Emergency Management's model ordinance. So that's what this will accomplish. So in addition, there will be modernized standards for future development, and it will also allow for the approval of any updated FEMA maps as they come online. Currently, the most recent FEMA maps, if you can believe it, were from 1982. So they're currently going through a revision process, and the date of the new maps being enacted has not been finalized as of yet. However, the anticipated date is July of 2017. So this ordinance would incorporate any sort of amendments to floodplain maps, which is a vital component of being in that community rating system. And just in summary, for the CRS system, the National Flood Insurance Program's Community Rating System is a voluntary incentive program that recognizes and encourages community floodplain management activities that exceed the minimum National Flood Insurance Program's requirements. As a result, flood insurance premium rates are discounted to reflect the reduced flood risk resulting from the community actions meeting the three goals of the CRS. Goal number 1 is to reduce flood damage to insurable property. Number 2, strengthen and support the insurance aspects of the National Flood Insurance Program. And number 3, encourage a comprehensive approach to floodplain management. And city staff recommends approval of this floodplain management ordinance.
Mr. Gagnon, the backup material that you just referenced, is that like a white paper or something, or a summary of what the CRS does?
I cheated and got this from their website. However, I didn't have it available for the stream.
Okay.
So.
Yeah, if you would send it to us after, or
Absolutely.
at some point maybe next week, I'd be interested to kind of follow back up. And if there's also a website reference, I think it's FEMA, right? Yeah.
Yeah, there's a specific website, and I'll be happy to provide that.
That'd be perfect. Any members having a question of the presentation?
Just two quick questions. One, once the flood maps come out, saying July of 17, what am I saying? 17, does that mean at that time we modify this?
So, in anticipation of that question, on page number 18 of the handout is the section that will enact any sort of amendments that are approved to the flood maps. So on page 18, on the top of the page, number 3, it's titled Basis for Establishing Flood Hazard Areas. And what that does is it says, as the maps are adopted, this code section, the way it's written, it will automatically reference the most current maps.
Page 18 of this section doesn't have that.
Should be page 18 of 39.
Subsection 3.
No, it's section,
Right, it's subsection 3 on page 18 of 39.
I see it on the handout.
okay, 18 and 39. Okay, so
I can pull it up on screen too. It's a pretty voluminous packet.
okay. Okay, I see it now.
So it's on the screen currently for the basis of establishing flood hazard areas. So it approves basically any subsequent amendment or revision to the maps would automatically be enacted through this ordinance. So in effect, it'll have that automatic use of the most current maps. So we won't run into the situation we're in now with our existing ordinance where we'd have to go back in and amend the existing ordinance to incorporate new revisions.
Okay, the only other question I had was on 25-1, which is on the same page.
Mm-hmm.
The designation, the city manager or designee. Shouldn't the city manager shouldn't it be like the city manager shall appoint a flood plan administrator?
I don't necessarily disagree with that, but this language, it's their model ordinance. So this is I can't remember their acronym now, but the Florida Emergency Management's model ordinance. So this was provided directly by them. So this is standard language that's utilized throughout Florida is what their goal is.
Okay, no other questions?
Any other members?
Mr. Chair.
I have a question about the flood district. Now, I know there's a map in the city, but now how do the citizens be able to get a hold of that map when they're buying here, they go get insurance?
That's a good question. One of the best resources, I think, is the city's building department. We do have hard copies of the maps here. I do believe they're also available online, and I can try to find that map link. It might be slightly more difficult to find that way because I think it's by a certain geographical area, but the information is available, and oftentimes as part of a buyer's due diligence process, they verify whether or not it was in any sort of floodplain. So normally that's determined prior to the purchase being approved.
Because I do remember several years ago when I was renewing my insurance after a hurricane, I asked the company about flood insurance, and they said, oh, you live east of 95, you're not in a flood district. But you could buy insurance, but it'd be real cheap, you know. So that's why I was wondering how much of east of 95 were they talking about, you see, because I know where I live, we got those canals and ponds and everything that drain off the water. And, you know, I don't know, after these Richard Matthews and all these people that hurricane, whether the citizens are going to be asking me that later on, because a lot of times they come up to me and ask me questions that I want to be able to answer them, you know. So I thank you very much for that information.
Ms. Shepherd?
Jeff, where I stay at, it's, I see it's posted evacuation zone. Please explain it to me. Why is the sign there?
Well, there are some areas that are designated as high hazard areas. So in the case of a large storm event, FEMA anticipates those areas due to their location or due to their elevation, that they would probably be the first locations impacted by any sort of storm event or flooding. That would be the reason why your property, your residence would be designated in that way. I believe that's what you're referring to versus just evacuation route posting, which is based on the roadway structure of the city.
So how would the residents be notified that, that we need to get out?
That's a really good question. I know.
So we don't know, we just see the sign, and maybe if the television say, leave, that would be a good idea.
From our most recent storm event with Hurricane Matthew, there were city staff members that did visit residences. So first responders, for example, would ensure that people within those high hazard areas that may not realize they were in the high hazard area were provided advance warning and had the opportunity to leave if they chose to do so. Again, there's always situations where residents choose to stay, even though it's advised that they leave in case it is a real natural disaster and catastrophe. However, that was the process that occurred during Hurricane Matthew.
Okay. Because the reason I ask, and I'm glad you're bringing this up, is because I was just walking. I just happened to look up on the pole, and it's way up. I mean, you really had to be looking up. And I'm just trying to figure out how would the residents, like the seniors, I know it's a lot of seniors in that area, how would they know? I'd like to know how would they know? I just happen to see the sign walking. Do the city notify them? Or I'm just trying to get a clear picture because, if I'm there and I'm listening to the television, I want to say, I think it's time to go, How does the city really...
Yeah. One of the components of the CRS is an educational component and a notification component. So I think that a really good idea, based off of your comment, would potentially be to have something on Channel 18, print off additional flyers that could be provided as handouts at council meetings, planning and zoning board meetings. You can provide information in the library, so at least have that educational component that is existing prior to any storm event. And then if we knew that there was a hurricane coming again, we'd once again have first responders that could go directly to residences to ensure that everyone that was in high hazard areas were well aware of it and had the opportunity to evacuate.
Thank you.
Any other members? Having no public comments, any board comments? Hearing no comments, is there a motion to approve the ordinance?
I move to approve the ordinance as per staff recommendation.
I second.
Mr. Velasquez?
Gillis Wiggum,
Yes.
Margaret Shepherd,
Yes.
Edward Kennedy,
Yes.
Cedric Barber II,
Yes.
Frederick McCoy,
Yes.
unanimous vote, motion approved.
So next we have, under new business, letter A, which is an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, amending Chapter 22 of the City's Code of Ordinances entitled Buildings and Building Regulations, Article 2, Building and Technical Codes, Section 22-32, Administrative Amendments to Florida Building Code, Chapter 1, Administration, in order to amend and supplement Chapter 1 of the Florida Building Code, providing for conflicts, severability, codification, and providing for an effective date. At this time, I would like to ask Allison Goldberg, our Senior Planner and GIS Specialist, to make a presentation to the board.
No, I don't know.
Good evening, ladies and gentlemen. Allison Goldberg, Senior Planner. So the goal of this amended ordinance is to provide a standardized framework that is aligned with the updated Florida Building Code regulations. In 2004, the Florida Building Code replaced Florida's assortment of codes and regulations that were developed, amended, administered, and enforced by more than 400 local jurisdictions and state agencies with building code responsibilities. The current code is now a single statewide code based on national models and consensus standards. It has been amended for Florida's specific needs in regards to design and construction. The code is designed to make the local building process more efficient, increase accountability, bring new and safer products to the market, increase consumer confidence, and better protect the residents of this natural disaster-prone state. The Florida Building Code is updated every 3 years, and we're currently at 2014, which is the 5th edition. This ordinance is taken from the building section of the Florida Building Code and the Chapter 1 administration section. The City of Riviera Beach is basically just amending it for the administration section. This code is broken up into 19 different sections. The first couple sections delve into what this code is for, who it applies to, and who enforces the contents. The middle and end sections relate more to the various building elements, the application process and procedures, different powers, and enforcement. So now I'll briefly go into some of the different sections. Section 1, General. So the code applies to construction, replacement, repair, and demolition. It establishes the minimum requirements to safeguard public health, safety, and general welfare through structural scent, means of egress facilities, stability, sanitation, adequate light and ventilation, energy conservation, and safety to life and property. Section 102, applicability. So the Florida Building Code, it does not supersede everything. Other jurisdictions and other agencies have some authority. So certain structures and elements are exempt from the Florida Building Code regulations as listed below. Section 103, the building division. So the building official is the person in charge, and they're in charge of administering and enforcing these regulations. Some of their powers are to review applications and permits, issue notices and orders, make inspections, approve materials and equipment, and they have the authority to grant modifications. The building official shall determine the extent to which the existing system shall be made to conform to the requirements of the technical code. Permits. So there are different types of permits. Most of the permits have an application period of 6 months, except for residential single family, they have 30 days. Floor and roof design loads, you need a certificate of occupancy, and it's unlawful to place a load greater than what's permitted. As for the documents that need to be submitted, you have construction documents, inspections, technical reports, and you must provide 2 or more sets of everything. So the building official is authorized to issue a permit but for a temporary structure, but it can only be for 6 months, and it must conform to building standards. For fees, the permit cannot be issued until fees have been paid. Inspections, so you have building inspections, electrical, plumbing, mechanical, and gas. Each one of those inspections have different elements that are reviewed during that inspection. Certificates of occupancy and completion, section 111. Listed above are the elements that are supposed to be included in a certificate of occupancy. So a certificate of occupancy is a document that's been issued by a local government agency or building department which certifies a building's compliance with applicable building codes and indicates whether or not it's in a condition suitable for occupancy. Service utilities, connections are not allowed until the building official or a certificate of occupancy has been issued. There is a construction special magistrate, which has to be appointed by the city council. It has the power to hear appeals of decisions and interpretations of the building official, and also to consider variances of the technical codes. And as to violations, the authority does have jurisdiction to impose fines, liens, or seek injunction relief or exercise any type of enforcement powers. For a stop work order, there has to be notice from a building official unless it's during emergency. And if a stop work order has been given, they must stop work immediately. Section 116, unsafe structures and equipment. It's related to Chapter 22 of our Code of Ordinances, which is abatement and unsafe building code. So if the Florida Building Code regulations and our Chapter 22 is in conflict, it will be resolved based on the code that provides greater protection to health, safety, and welfare of the city. Variances in flood hazard areas. As Jeff had mentioned, it's the local floodplain management ordinances that will apply, as well as the Florida Building Code, building and residential sections. If any section, subsection, sentence, clause, or phrase of this code for any reason is held to be unconstitutional, such decision shall not affect the validity of the remaining portions of this code. So city staff recommends approval of the administrative amendments to the Florida Building Code, Chapter 1, the administration. Thank you.
Ms. Goldberg, I got a couple questions.
Okay.
If you were, I imagine you were reading off of some sort of notes. Is that going to be provided to us as well?
Sure.
The reason I ask, I'm particularly interested in the portion in which you mentioned that one of the, whether it's the code or the building, whether it's our existing code or the building code, one would prevail.
Yes.
I couldn't quite make out which section I was in because you were going pretty swiftly. I imagine it's in the severability
It's
portion.
in section 116. It's directly in the code on page... Page 55, the last page.
Okay. Now, the special, that's the construction special magistrate. That's the first time I've heard of such a position or such a role. Is that something new to the city of Riviera Beach? I think you referenced that it had to be appointed by city council. If you can click back in your presentation, I know I've seen it up on the
It's
screen.
113.
Okay, now are there promulgated rules regarding some of this? Because I know we have ordinances, but how do we go out from a staff level that these are administered? Because I'm just curious, is this just the framework and then does staff come back and draft rules or promulgate rules, or does some authoritative office then promulgates how the policies are then drafted? Because it's definitely a good start. I just want to know, is the public involved on the latter end of it? Like, for instance, the rules in how a special magistrate or, at what point would a contractor or a homeowner want to go to the special magistrate? Has those already been created, or what's the process that a person should expect?
Yes, I do believe there's a defined process already in place. My understanding of Section 113 relates more directly to the unsafe building process. So if there is a situation that either a structure has deteriorated to a state where it's no longer habitable or it's no longer safe for human use, then we have an unsafe building process for that. Or if construction was mid-process and let's say a contractor had been performing construction work without the proper building permits, and there's a stop work order issued, we could also bring them to the special magistrate for any sort of relief or determination of how to move forward legally.
And I hope I'm not getting too tied up into the technical details, but is that the same as the code enforcement magistrate?
It would be a different appointment.
So it's not the same person?
Well, I guess technically speaking, it could be the same person, but there would be different positions,
Okay.
different functions.
And also, I didn't see it in there, but there was no, like for instance, I know that slide, she went pretty quickly, that spoke of the exemptions to this Florida building code, and there was family mausoleum or something like that, movie production. Okay, there it is there. These exemptions, are they, I imagine those are already existing in our current code or in some form?
Yeah, a lot of the exemptions from the Florida Building Code have been determined to be that way by the state of Florida. So, for example, one thing that we've seen come through a few times is third from the bottom, which is the chickee hut, or it really appears to just be a gazebo, but you have to have a certified tribe member that would perform the construction, and that would be outside of the scope of the Florida Building Code itself. So those exemptions have been, I guess, provided or determined to be exempt from the Florida Building Code for various reasons. And normally there's other legal acts that allow those entities to kind of supersede any sort of local authority. I think that's the main reason why.
And are there any definitions to describe those? Because a mobile structure is pretty broad. And, are we talking about a mobile structure that's on something that's on a automobile? Are we talking about a mobile structure that's on a trailer? I mean, those kind of things. And I'm not asking you, does the statute...
It's in the code, page 11, 102.2E. It has the definition.
Pardon me. Okay, I didn't see that. One other question while I look at that is the fee schedule. That's not established by the Florida Building Code. Isn't that still something that we do?
No, sir. That is established through local ordinance.
Okay. And I think that's it for now. Any other members with questions?
I have a question.
Yes, I have one question.
Mr. Wiggum, let me get Mr. Barber first.
Okay. Back to section 113. I believe that was subsection 116. As far as the magistrate is concerned, I guess my question is there a process put in place, and if so, what is it, as far as appeals are concerned from the magistrate? So I know the magistrate is an appellate, is placed there in an appellate role.
Right.
But in the event one of the parties isn't satisfied or is unhappy with the decision that the magistrate makes, what recourse do they have, and if so, is it laid out in the ordinance here, in the proposed ordinance?
In most circumstances, the magistrate would function as the final determining factor as far as the city involvement. And after that point, I think you would have to seek relief outside of the city process. So I think it would be through a structured court process, through just the Florida court system.
Okay. And in 113.4.2 decisions, I just was wondering how we came up with the term on the second line, without unreasonable or unnecessary delay. The section doesn't seem to define each term, and I was wondering why the lack of specificity, and if the staff considered that when constructing the language.
That is a good question. I know that a majority of the language here is the standard language that's provided within the Florida Building Code. So there have been a few minor administrative changes. However, my understanding is that's the way that it would currently appear in the Florida Building Code. And I don't believe that staff had modified that. That doesn't mean that staff doesn't have the ability to potentially modify it, but I don't think that staff look to do so at this time.
My only concern is, when you're talking about a project, whether it be a developer or an individual with his home or her home, making new renditions or upgrades to their home or their building, substantial delay, and the difference of opinion in what that delay is could feasibly, reasonably come up to, cost. It can cost a lot of money. And so I think if we're going to draft this language, whether it is mirrored after the state's ordinance or not, I think it would be prudent or most prudent to put a time limit on when a decision should be made. Because without one, I think we run the risk of creating risk or potential risk. That's all I have.
Mr. Wiggum, are you want to make a comment?
I have one question. I didn't see it in here. I might have missed it. In doing the development of homes and major projects, like big development buildings, are these buildings required by law to put storm windows in that won't break, rather than having shutters and stuff?
Excuse me.
I believe that the most current Florida Building Code requires storm windows, and you have to meet a certain wind rating. So any sort of new development would have that storm window in place, and unfortunately, the older development wouldn't have that requirement. So oftentimes you'll see storm shutters or other methods of protecting the property. But I do believe that new development does have to meet certain wind standards for certain, and I believe those requirements also require storm windows.
Thank you.
I have another question,
Mr.
Chair. Yes, Chair.
Mr. Barber, if you can defer for just a moment, I want to allow Mr. Canuti the opportunity.
Sure.
Okay. Just one question on 102.1.1. I was a little, I wasn't sure I understood that. It says the Florida Building Code does not apply to, and no code enforcement shall be brought. And my question is, does that mean, is that relative to the items in the last sentence, correctional facilities, juvenile justice facilities, and so forth?
So it was 102 point.
102.1.1.
Okay. I think that what this section is saying is you can't use or utilize any sort of building code enforcement procedures if there are any sort of lack in meeting zoning requirements or land use requirements. I believe that's how this is stating that section.
It just seemed to be contrary to everything else, which was saying Florida Building Code is kind of like the Bible for everything, and then it starts off with Florida Building Code does not apply.
Do not pertain to enforcement of the Florida Building Code. So I believe the second half is almost an exemption section where it states these certain facilities have their own guidelines. So the correctional facilities, state universities, things of that nature. Let me reread the top one more time.
Yeah, well, basically, that was my question. Is that all of the verbiage up to that last sentence, is that just saying that these are exempt? But if you go back to the exemptions that we had, okay, it seemed to be somewhat different, okay, than what this paragraph is saying.
Mr. Gagnon, and if I could offer,
Yes, sir.
my reading of it was the section in which the exemptions occurred exempted the type of structure, and 102.11, which you were just referring to, Mr. Canuti, exempted the actual authoritative bodies like the state agencies. Like, for instance, I know the school district has their own building department that they don't come to the city for building permits.
Right.
And I imagine that would be the same for state universities and community college. Imagine they have a separate building official or permitting process.
Well, that was my question. That was basically my question. Is that just referring to the specific facilities they talk about, correctional facilities, etc., public education?
Right, as provided by law.
Yeah.
But I know certainly legislatively within the last, I want to say 7 years or so, the legislature granted the school districts the authority to do their own permitting process.
Right.
So I think that's why that would be applicable in that sense.
Well, then that means that correctional facilities, juvenile justice facilities, state universities, community colleges also have the same authority.
I believe that interpretation is correct. I think the way that the section is worded is somewhat unusual as far as having someone that's not a building official read it and understand it instantly. But I think that the intent after reading through it and working through it and a discussion is basically what we've concluded to be these specific facilities, as the second half of the paragraph defines, really cannot be subject to code enforcement action or any sort of other Florida building code requirements because they're governed through separate code structure.
Okay, well, that's kind of what I thought. But that does that mean that if they were going to put up a college on a piece of property, that they're exempt from the zoning?
I can give you two real world examples. It's not a college, but one was the Clean Energy Center that was built by NextEra Energy because of the Power Plant Siting Act. They were exempt from almost every aspect of local zoning code or regulations. The other, which happened years ago now, but the VA hospital was able to design and construct their hospital really without any sort of local zoning codes or conditions coming into play. So, in essence, I hadn't had personal experience with a state university, but it seems as if that would also fall into a special category or class, and they would have the ability to almost govern themselves.
No other questions.
I do have one question. Interesting enough, I spent some time at the Universal Studios this past weekend, and I was just looking at some of the things there, and I was like, what building department actually allowed this to be created? So I imagine there must be some sort of exemption in there for places like amusement theaters and some of those recreational parks, because even the Rapids, for instance, like, you know, I haven't been there in a while, but I know just from Military Trail, you can see like some of these structures are going across an actual roadway, and I don't know if it's a public roadway or a private roadway, but still, I didn't know if we had, and it just came to my mind, do we have any involvement as far as the permitting of a structure that, you know, crosses over a private street that actually still existed in our city, which the Rapids, as we know, is still a part of the city. But, you know, those are the kind of things that I kind of look at when I read this. And also, one of the things that I was thinking about when this whole section came up was, where does that put us as it relates to code enforcement? Now, I know that the city has done, I don't know if it's preemptive, if that's the correct word to say, some preemptive measures as far as code enforcement is concerned. But even from the building aspect, does that preemption of a vote that occurred back in, I think it would have been in September, does that then further make some of these things moot? Because if there's not code enforcement on certain unsafe structures and some of those things, is this even applicable in those situations? And not only that, is this just the framework? Do we work off of this? Should we expect that something was going to come back before the board and before city council that's more stringent, that allows for more regulation on some of these things? Because I think at a minimum, I would almost agree with the Florida Building Code, but I'm just concerned where we are in the city with code enforcement and some of the building that's going on in the city. Do we build off of this and make our rules accommodating to, I guess, our geographical area or the circumstances that exist in Riviera Beach? Because, if we, this is like a working document that I think we should always revisit on the regular. And I think it makes good for something like this, but I just don't think this goes far enough, especially with the number of code enforcement issues that we have in unsafe building structures. This is certainly a start, but do we go even further? And this is the actual question. Those were my comments. Is this exactly the boilerplate language that came from the Florida Building Code? Did we not add anything additional to this? And if it is something additional that the city added, can that be delineated or separated, or that we can actually see?
Yes,
if it's not too much trouble.
I'm sorry. Yes, there are a few minor amendments at the end. It's page. Unfortunately, we don't have the strike-through underlying document, so there had been some modifications, and that was at the directive of the previous building official as far as how the administration of the code would work. So we could prepare a strike-through and underline, but the changes, from my understanding, the changes have been
incorporated.
They've been incorporated in this document, and they're of more of a minor nature as well. And the majority of the framework has been utilized from the administrative section of the Florida Building Code.
I'm cautiously optimistic, and I say that because I think this is great, but I think this is going to be vetted out a lot more at the city council level. Just because the city council has decided to take a different direction as far as code enforcement, I don't see that this is going to pass on the first reading. I think that there's going to be a lot of spirited discussions about especially the word code enforcement and some of these things. And I know that I can remember, and you may recall that we provided for accommodations, reasonable accommodations for ADA when code enforcement, when there's issues of code enforcement or applying the code. Is that also included in this?
There's 9 different sections of the Florida Building Code, and one of them is accessibility. So all of the ADA compliance is typically found in that section of the code. This is only taken from the building section, and it's only chapter 1.
Okay. Well, Allison, I certainly appreciate that, but I know maybe a year and a half or 2 years ago, maybe even more, that we took up something specific to reasonable accommodations, that there would be no enforcement when there was an issue of accommodations. Is that incorporated into these changes?
That's not a part of this document. So I think what you're referring to is certain classes of individuals or protected classes of individuals as specified by the ADA laws. can apply for reasonable accommodations to allow for them to utilize their property or their residence in the same manner that any other resident could. So for example, if, say there was a 10-foot setback requirement on the side of their property, however they utilized a wheelchair for mobility, and they needed to have a specific pathway within that 10-foot setback. So what that reasonable accommodation would do is allow them to provide documentation to the city and state a reason why they need to, in essence, trump the local setback regulation in order for them to have equal use of their property. So I think that's what you're referring to, but that's not part of this.
Okay. Any other members? Mr.
Yeah.
Barber.
I have some questions about section 114, violations, page 54, 55. It seems as though in this section, a lot of the acts outlined, actually all of the acts outlined are being criminalized. And so any violation of the code seems to result in a misdemeanor. So first of all, I think we want to be very careful about criminalizing individuals or citizens for violating each and every part of the code. And I do believe there are some things that perhaps it would be reasonable to result in criminalization or result in a conviction or misdemeanor. But I think those things need to be maybe enumerated. And so we can outline specifically what results in criminality. Something as simple as, making an alteration in your home, one may not be aware that they're violating the code and therefore violating the law. And I don't think it would be the best thing for the city, for the citizens, or for the board, or anyone for that matter, for that to result in criminal liability. And so that's one thing. Secondly, as I read through the language at the beginning, it says that any violation will result will result in the individual or entity violating the law receiving a guilty conviction of a misdemeanor. And then as I go down, almost in the same breath, it says upon conviction of any such violation. So in one breath, it seems like the language already spells out by violating this, you've already committed a misdemeanor. And then at the end of the paragraph, it then says, well, you have to be convicted. And so I think that's something that the board might want to reconsider or reconfigure so that it reads clearly. Typically, I'm sure you all know that in order to be guilty of a misdemeanor, you have to be found guilty. And becoming guilty of that misdemeanor is a conviction. So that's something I think the board should look out for. But yeah, that's all I have for that section.
Any other members?
Yeah.
Mr. Canuti.
Yeah, on that same section, I guess I'm maybe reading it a little differently. It's enumerating I think to be convicted of a misdemeanor, you're an attorney, so correct me if I'm wrong. You have to violate a law.
Correct.
Not an ordinance.
Correct.
Okay, so you have to violate a law. And
Well,
the way I'm, go ahead.
Go ahead. I'll wait.
So the way I'm reading it is during any violation of any of the provisions of applicable codes, comma, laws, comma, ordinances, comma, rules and regulations is committed to or continued, and upon conviction of any of such violations, such person shall be punished with the limits as provided by the state laws. So I'm saying if you violate an ordinance, there's one set of punishments that go with that. If you violate a law, there's a different set of punishments that go with that. So that's kind of my interpretation.
Mr. Barber.
Well, my reading of the language, and again, that's at the bottom of the paragraph, but at the top of the paragraph it says, any person, firm, corporation, or agent who shall violate a provision of this code or fail to comply therewith, any provision of the code, or within any of the requirements thereof, or who shall erect, construct, alter, install, demolish, or move any structure, and it goes on to lay out a number of things, without full compliance with the ordinance, with the code,
Right.
mind you. And it says specifically compliance with applicable codes, laws, ordinances, rules, and regulations. So that's not just law, so to speak, or state statute. That's ordinances, which in this case would be the one that we're talking about adopting today. That's rules, that's regulations, shall be guilty of a misdemeanor. So at that point right there, according to this language, which is why I pointed it out to staff, that maybe they want to reconsider reconfiguring the language. At that point right there, they've already violated the law and therefore can't be found guilty of a misdemeanor. And so I think what you're saying is right when you get down to the bottom, but I think you're kind of putting the cherry before the horse if you add that language there as well.
And if I can add, Mr. Canuti, I believe you can be charged with a municipal ordinance. That's a misdemeanor. It doesn't have to be a state law, but I've known of cases where people have been charged with municipal ordinances that are misdemeanors. And it's not necessarily a violation. Well, it could be a violation of the state law, but you're brought up under municipal ordinance law. That's a misdemeanor. But, Mr. Barber, I appreciate your diligence in knowing that, because that's why I asked the question about the process in which the rules will be promulgated. We would do a blanket passage on this, and just hypothetically, if it passes on council first and second reading, the mere fact that rules haven't been promulgated or provided to us when we're making this decision pretty much gives unfettered discretion by the city or the building official to charge somebody with a misdemeanor offense when we don't even know if it's, we don't know what the rules are, and it could be a minor deviation of something in the code, and it could be with just cause. It could be unwilling, So that's something I think is certainly worth revisiting and figuring out, how do we address those deficiencies.
If I may,
Mr. Barber?
If I could just give some advice to staff, in order to be convicted of a crime, you need both mens rea and actus rea. And so you may want to incorporate some need for intent to violate the law or violate the ordinance in order to be convicted and get that misdemeanor, and that might cure the entire problem.
Miss Busby?
Yes.
From the legal perspective, is this something that, certainly I imagine there's some legal review that's necessary. Is there anything that you could offer, at least as to what Mr. Barber introduced?
Well, you can agree to whatever you want in your section on violations, but you certainly want to have some sort of teeth in the code so that you can enforce things. It might be a good idea to put an intent, but you don't always need to have an intent component in a crime or in a misdemeanor. There are crimes that are just statutory. So, it's up to you, the board.
Okay. And my next question, has this been through a legal review?
Our office has not reviewed these in detail. So not at this time.
Okay. Any other members?
That's a good point, and my question for staff is, normally something like this passes through all the departments for at least a look-see, and has this, and should this?
I don't believe it has, but we'd be happy to do so.
Members, if we could just kind of postpone our discussion. I do have a public comment card, and I would love to hear what the member of the public has to offer. Miss Mary Brown.
Sure.
Miss Mayor Graham, Riviera Beach. I was at another meeting, and apparently we were discussing about some codes for updating some of these codes that are on the book, as well as putting some teeth where some teeth need to be put at in some of these codes here. Now, I'm going to get a listing of this presentation here, because apparently what I'm just going through this book here seeing, I think that you all should not be in a haste to go ahead on and then approve this until you all have the incremental time to dissect, to go through here and really understand some of these viable codes that are being suggested here. Because, like I said, I just left out a meeting here with the city here, and we were talking about some of these codes that are in here. My next thing is, last year over on Broadway, I'm just reading about this termite here, all of this here. See, even Miss Graham here pulled out some things that I wanted to address, some things here. When those buildings was knocked down over on Broadway, my question is, I see where you say you get a certification or some type of certificate. Termites was just exposed within our city. Even when some of those homes was knocked down over on MLK, a tent was not there. So we're talking about termites within our city. Last year, I addressed this. I made mention to the previous Miss Ruth Jones about the influx of termites in our city. Now that building that was over on Broadway there that was knocked down, it was infested with termites. You could see the white termites all, like the neighbors said, all over on that side there. Even over on 8th Street here, when they knocked down those buildings there. They were not tenant. Jeff, those buildings were not tenant. So we need to find out, we need to go back and structure and find out, are we really applying what we should be applying when it comes down to code findings for these type of things? Because sometimes you let people come into the city here and they just do demolition. So that's one of my things. The other things that I would say too, that with these codes here, do not take this lightly here. Do not take this lightly. This board here would set this and it would come before the council. But some of these things need to be really, you all really need to read these things. Find out what was there, find out what is workable, and find out what needs to be put some teeth in. Because like I said in the previous meeting, our codes do need to have some teeth in them. So I'm going to leave that with the board, but I do not wish for this board to be rapidly hurried into doing this. Because I do agree with some of the things that Mr. Barber was saying, as well as, you can't, by being the law, but the city also, you are the lawmakers here when it comes down to what is applicable for this city here. Strengthen the laws that needs to be strengthened. Some of these little minute things is a little bit minute, but the termites and other things that I'm as a resident and other residents have seen in this city, we have been asking for these codes to be updated in this city here and put the teeth where the teeth need to be put. Thank you.
If I may.
Mr. Barber, you recognize.
Just a quick question. Has staff considered a board as opposed to a single magistrate?
I think the inverse has happened in recent history, and that's partially to do with maintaining the structure of the board, I believe, where, even using the planning and zoning board, for example, it's sometimes difficult to maintain the full board structure that's required. So the most recent example is the development special magistrate that was formed, and that entity replaced our zoning board of adjustment, which had become into a defunct board, and this probably happened about 3 years ago now. So I think that the opposite is currently trending.
The opposite being the magistrate.
Right, so define magistrate versus a board system.
Are there any specific qualifications that a magistrate may need, or is that laid out in the, I guess, certain criteria laid out in the proposal?
For the development special magistrate, there were specific criteria that were required by that entity or individual in order for them to fill the position. We'd be happy to look back through and see what those criteria were for the building magistrate as well. I'm anticipating that the criteria are there, but I think it'd be a very good idea to verify that it's in the structure that we want.
I agree.
Any other members wishing to comment? Well,
Yes. I like to.
one second, Ms. Shepherd. Comment prior to making any kind of motion or recommendations as to this. So now is the time. You recognize Ms. Shepherd.
Mr. Gagnon, can I go back to what Mrs. Mary Brown was saying? Because I was at a function and they did knock the building down, and the termites was really just flying all over the place. Are you required to have that building tinted, or no? Is that an ordinance, I guess I'm trying to say?
I'm not aware if there's a fumigation requirement prior to demolition. I would have to look into it and give you the exact answer.
Okay. Thank you.
Okay. Mr. Canuti.
Yeah, my only comment is, it seems like there's quite a few questions that have come up on this particular section. And my other comment is, it's a complicated segment, and I think just a suggestion for the future is to give us a little bit more time and a little more backup when we have something as complex as this, so that, we can understand it better, and, develop better understanding of it. So, only comment.
Okay, and I don't know what the feeling of the board is, but I would feel more comfortable knowing what the strike through and underline version is, because if we're leaving out something that's critical to how the city has been operating and we forego that, I certainly want to know what we're giving up. And if there's something that this new building code, as well as our existing code, doesn't capture, I want to also know that as well. I think this has to be revisited. How? I'm open for members of the board to make a recommendation either way, but I just think we should have it in some form or fashion come back before us with some, I guess some additional backup, or maybe some recommendations, or even some sort of, I guess, suggestions or opinions by the legal department, if, that's the pleasure of the board and staff. So, if there's no more comments or questions, the floor is open for any kind of motions or anything of that sort.
If I may, Chair, prior to the motion, The current language that's in place is provided in strike-through format on the first 8 pages, and it seems as if the overarching discussion tonight has identified a few areas that staff needs to go back and review. So I think if the board wishes to make a motion, they can, but I think the best action at this point would be to have staff go back and work on the specific comments that the board members had and present it again in the near future.
So for parliamentarian purposes, do we just withdraw it, or does there need to be a motion directing staff to?
Well, we will proceed as directed. However, I think there are, again, some outstanding questions that require some answers, and if the board wishes to direct staff to come back, then that's perfectly fine as well, but I think that would be the best way to proceed.
Okay.
I have a question for our attorney. Yeah. I know there's a particular wording to postponement. I mean, not table, not postpone, but what is the correct word to send this back to staff?
I'm not sure if there's a particular word, but you can make a motion with that intent, and that will suffice.
Okay. Well, I'll make a motion that we send this ordinance back to staff and have them answer the questions that were brought up by this board and resubmit it as soon as possible with some additional backup to clarify some of the points. And I also think it would be a good idea to at least pass this through. Well, the motion should have each department review it, including legal, and make their comments, which would be part of the next submitted package. So,
It's been a motion. Is there a second?
I second it.
It's been moved and second. I do have one question before we take the vote. Mr. Gagnon, do we currently have a building official?
We currently have a consulting firm who's providing a building official for the city. The name of that firm is CAP Government Incorporated.
Okay, thank you. It's been moved by Mr. Canuti and second by Mrs. Shepherd. If you would call the roll.
Julius Wiggum,
No.
Margaret Shepherd,
Yes.
Edward Kennedy,
yes.
Cedric Barber II,
Yes.
Trudgick McCoy.
Yes.
Motion approved. 4-1 with Mr. Williams dissenting.
Thank you. We're now going to take up the addition, item number C, Park Manor platting.
So there was additional item number C, which is Park Manor Plat number 2. A hard copy has been provided to the board. This is in relationship to the Community Development Corporation's construction of single-family homes. And staff has a brief presentation. So the Riviera Beach Community Development Corporation has made a request to subdivide a parcel of land known by PCN 56 43 42 33 06 006 0041 into 2 parcels in order to build 2 new single-family homes. The request meets all city code requirements, and staff recommends approval of this subdivision request for Park Manor Plat number 2. On the screen before you, in the red outline, is the current parcel. And what the plat will do is subdivide this right at its midpoint and create 2 separate lots. So here's the plat in full shown on the screen. And if you zoom in closer, you can see again the outline of the entire parcel and the proposed subdivision, which would create, I believe, 75-foot lots. And again, this is a proposal from the CDC, and they're actively working in the community to create infill housing. This is part of their, I believe they call it the Renaissance Housing Program. And I believe there was a ribbon cutting ceremony for properties just south of this location on 13th Street. It may have been today, but it was very recent. So city staff supports this and hopes that the Planning and Zoning Board does as well.
I have a question, Mr. Gagnon.
Yes, sir.
Those lots haven't been constructed on yet, have they? Lots
I
3A
believe
and 4A.
that initial foundation work has been permitted for these two lots, but as part of any permitting, there was a stipulation that no certificate of occupancy could be granted until this replat and subdivision occurred.
Okay, I have nothing. Any other members' questions or comments of the presentation? Hearing no questions or comments and having no public comments, is there a motion on the replatting and subdivision of this plat?
So moved as per staff recommendation.
It's been moved.
Second.
Moved by Mr. Canuti, and there was a second by Mr. Wiggum. Roll call.
Julius Wiggum,
Yes.
Margaret Shepherd,
Yes.
Edward Kennedy,
Yes.
Cedric Barber II,
Yes.
Trudwick McCoy,
Yes.
unanimous voting, motion approved.
Thank you. And moving on to general discussion, I do have one public comment card, Ms. Mary Graham.
Miss Mary Graham, B-R-A-B-H-A-M, Riviera Beach. I'm speaking in reference to, you do not have this, but the community base is well aware of it. Not just the city of Riviera Beach, it's all out in the country now. This Odyssey manufacturing here, this detrimental bleach, hazard material, that the companies is asking for a special exception. That word, special exception. We don't have to do this. They was turned down everywhere else where they tried to come. And they're anticipating on over by Stony Brooks. It's enough disaster over in that area as it is. So I'm asking this board, don't do that. Don't do that. You talking about an upheaval that will be in this city here. You have a railroad track there. The tracks that we're not anticipating any danger, but hopefully it will not be any danger. Those tracks can go off and the bleach will explode and blow us up. Miss Brown lives over there, not just Miss Brown. Other residents, the lawyers lives over there. Head Start is over there. The schools are over there. You have 13th Street over there, where they anticipate and want to put the police department over there. Don't do this. You all did a travesty when those poles went up in our city here. Miss Brown was a little bit ill there, but we would have came in here. We would have voiced our concern. Because, see, Margate didn't want them. All down on that end didn't want them. But that deal was pushed. So I'm asking this board here. They're asking for a special exception. That was just like the car. All of that hazards there that's already impacting those people over there. And you have to remember now, they're anticipating a gas pipeline coming in the back between Mangonia Park over there. So how much hazards can you as a board want to be governed over? EZ Well. I spoke in reference to EZ Well. You see what happened over there. People's coming to your city here and they sell you a bill of goods and then they leave you out with all of the damage. Suncoast's over there. All of those elementary schools are over there. But most of all, it's human beings over there. So as a resident and other residents, yes, we're well aware of it. We're well aware of it. And others are well aware of it too. And we say no, not on our watch. We can do better. We're here as a city for business, But it's not the business, but it's what the business represents. We value the business. We value anyone business. But it's what you want to bring in that would inflict this city and impose upon these residents, especially my children. It won't happen. Not on our watch. Because we will do everything in our power to let you know that this is another travesty. Our water is already all over the country. And this bleach chemical that you all want to anticipate somebody up on that board there is anticipating on doing, Ms. Graham is asking you all to think twice now. Because we are tired of this. We are tired of the devastation that's being brought into our city when other cities and municipalities will not have it. They won't have it. But the reputation of Riviera Beach, you know we have some very little minute like-minded people. Do you throw them a little brown coin and then they decide on bringing devastation into your city? Because see, they brings it in and then they gone because they do not have to live in here. So I wanted to put that on record tonight of what we know that is going on in this city, and we say no. Thank you.
Mr. Chair.
Ms. Shepherd?
Mr. Gagnon, can you clarify what Mrs. Brown was talking about? I'm not sure.
I believe Ms. Bram brought up a few points, but the one I think she was focused on was a site plan proposal that was received by staff. The project name is Odyssey Manufacturing Company, and it is proposed to have a bleach distribution facility, and it's the parcel adjacent to Stony Brook. Staff provided the applicant with their first round of comments, I believe, last week. So the project is still in staff review phase. I believe that's what Ms. Brown was referring to.
Can you clarify it a little bit more? It's a bleach product, as in bleach?
The current proposal is to have storage of bleach on site and distribution of the stored bleach from that area itself. There's also a warehouse component that's currently proposed, as well as other outside storage, I believe. But again, the project, being that they just received the first round of staff comments, it's still, I guess I'll call it a new project as far as review from the staff's end. We have not received response to staff comments as of yet. Again, the applicant just received staff comments last week.
Thank you.
I have a follow-up question. This is the first that I've heard about it, and I don't think anybody on the board that I know of, we've been formally provided with anything related to any site plan application. But if you guys reviewed it, a question I do have is this use zoned currently, or would they come in under a special exception?
So the uses that are being requested are designated as special exception within the zoning designation.
And being that I don't know exactly where this is, or I just, obviously from what Ms. Bram stated, I would suspect around the 13th Street and 8th Street area. What is the zoning designation at this particular parcel? If you can speak to it, I know you don't have it in front of you.
I believe the current zoning is general industrial.
Okay.
And what I'd be happy to do, being that the staff comments is public information, I can provide them to the board. That would help.
Yes, because,
Just
you know,
inform the board if you receive any other questions from the public.
I would really sincerely insist, because, you know, we get asked this stuff, and this is, I'm sure this is the first, I'm positive, and I can probably really say that with confirmation that we've not received anything formally from staff about this.
No, sir.
And, you know, I don't want to be, you know, I don't want to find out from a member of the public and we're at a disadvantage because we don't know, or we don't have all of the information that someone else may have. So certainly, you know, I guess if you could provide that to us as well.
Just if you may, as I guess a word of information, a word of caution, that the project could eventually come to the Planning and Zoning Board, so any sort of sunshine laws could apply as well. So
Sure.
I'll be happy to provide the information, however, just treat it with that in mind.
Thank you, and I hope all the members are reminded of that, because I certainly would not like to see that happen. And I honestly just want to know, in case someone asks me, and now I'm curious that it actually came up tonight. Any other members?
Real quick, Mr. Chair.
Oh, I'm sorry. Just a moment, Mr. Barber. Mr. Gagnon, do we have any correspondence?
Not tonight, yes, sir.
Okay, Mr. Gagnon, you're recognizing planning board member comments. Mr. Barber?
Yeah, real quick, Mr. Gagnon. Do you know or remember if staff had any reservations about the hazards that could come about as a result of the project, and if so, what they are?
I will say, personally, I have reservations about the project. I would rather provide the staff comments in the complete packet, just to be as, I guess, formal about it as possible and not, I guess, speak out of turn about the project. But I'd be happy to share all the staff comments that have been provided to date.
Okay.
Mr. Chair, may I ask one more question while it's on my mind? Jeff, is this the same area where they tried to bring in the company next door to Stony Brook? I can't remember what.
Yes, ma'am.
The junkyard. Okay, is that the same general area next door
That's
to
the same property.
the same property next door to Stony Brook?
Yes, ma'am.
Okay, I get it. Thank you.
And I think while it was actually brought up by a member of the public, and I don't know if this is a question for legal, is this a situation where this is not right before the board and we shouldn't be having these kind of dialogues because there's not been anything formally produced to us for review? So is this like improper as far as is it right before us to kind of consider and have these kind of discussions on something? Because, you know, honestly, we haven't seen the packet, and I'm not saying any way, but I just don't want what will happen is, and as you probably know, and certainly Mr. Barber is aware of, if we take up something and we're, you know, potentially biased before it even gets here, does that then potentially offer up a opportunity for someone to come back and say that we were biased from prior to even getting the actual submission?
You mean like a discriminatory action?
Right. We were biased. We were not impartial.
Well, you're having a discussion now on an item you're saying that you don't have all the backup to, and you haven't been introduced to it, correct?
Correct.
If you were to not, I mean, the question would be whether or not you followed the law in, you know, approving that zoning or whatever, you know, decision you're making.
Okay. That's fair. I just wanted to not start the conversation until we made sure we had everything, you know, and then I didn't want anybody to come back and say what we did on September the 27th was improper, you know, so that's all I wanted to kind of be aware of, that we weren't starting a conversation and we did have it. Now, certainly, I would invite you to send us the public documents if they are public, but I don't want to, you know, deliberate on something if we don't really know the fullness of it, like, for instance, staff's perspective. So I think it's probably appropriate. If you want to send us the document, I'll gladly review it, and, you know, we'll certainly take it up when it comes before the board. So any other members wishing to comment on general comments related to P&Z or the city? Hearing none, Mr. Gagnon, any updates on the projects?
None for tonight. However, I believe that the project list is due to the board, so I'll send that out in the email as well with revised project updates.
Okay. And upcoming meetings?
Yes, we have our next tentative meeting date is November 10th. At this point in time, I'm not sure if we will be able to make adequate revisions to the document that we reviewed tonight. And then after that, there would be holidays, so following that November 10th date would be December 8th. And that will keep the board posted on whether or not the meeting will adjourn at least a week in advance.
Okay, perfect. Is there a motion to adjourn?
Motion to adjourn.
So
Second.